Hello, everybody. Today, our guest here is David Bonaccorsi, a real estate attorney here in California, Bay Area. Let's welcome him.
Thank you, Cindy. Yes, my name is David Bonaccorsi. You did a good job pronouncing it. I am an attorney in real estate based in Fremont, Newark. I graduated, though, undergrad and law school from Santa Clara University in the middle of Silicon Valley. And after I began practicing law, I've also been in public service. I was 10 years on the Fremont Planning Commission and 2 years on the Fremont City Council. And as a result, I've been able to balance my real estate practice with understanding housing laws as they impact our communities. And so I'm here and happy and looking forward to answering some of your questions.
Let's talk about the state moratorium deadline that's coming up. And we all know that it's ending on September 30th. What do you think will happen next?
Well, here, this is less projection and more of an understanding of the legislation. And you asked me about legislation before, and so I was almost like a political scientist, and that was my undergraduate degree, was political science. Now I'm going to be wearing my lawyer hat, but I want to make the disclaimer that I'm not giving legal advice. This is informational in the same way as my answer to your first question was informational. But so I want to make sure your listeners hear that. But I have been following the various moratoriums since they were enacted in March of last year. And I've had the honor of being invited to various real estate groups beginning in April of last year, all the way up to the most recent one I gave was in August. And I suspect I'm going to be doing some in October as the moratorium is lifted. These are normally 1-hour seminars. I've got PowerPoint material. I'm not going to be doing any share screening with you. We're going to just talk it through. But I will summarize what's happened and why we're here. We didn't have any statewide moratorium until September of last year. Before then, they were enacted at the county or city levels. They had the authority to do it. The state finally got involved in September of last year. It was supposed to have expired in February. And then it was extended through more recent legislation in September. And I was listening to Governor Newsom at his September 27th news conference that he gave live in Alameda County. And he reaffirmed what we had been hearing, that the legislature ended their session in early September before the recall election. And they're not coming back. So the moratorium really will expire. There was some uncertainty in my mind, at least, and some other observers, whether you might call a special session and extend it. So you're right. It's going to end on September 30th. But what is in effect right now, at least on the residential end? And if you want to hear about the commercial moratoriums and their effects, I can talk about that too. But AB 832 is the current law that was passed. Again, I mentioned it, actually, it was two segments. So September of 2020, it was supposed to expire at the end of February. At the end of February, they had urgency legislation that extended it to June 30th, and AB 832 was enacted right on June 30th to extend the moratorium to September 30th. So that's the third segment of time, and it ends. But AB 832 has a tail to it, which means that from really September of last year, actually, if you go all the way back to March, there were rules created about past rent due that will remain in effect. Okay. So if you're looking at what happens after September 30th, historically, somebody could give a 3-day notice to pay rent or quit. As of October 1st, if they don't pay their October 1st rent, I believe you can do the traditional 3-day notice to pay rent for rent due in October. But you can't claw back and reach back to all the rent that's not been paid under a 3-day notice. If you're going to do that, you're going to have to give them the 15-day notice, and they're going to have to, and you can collect no more than 25%. And then if they fail to pay that 25%, then of the rent that was past due, then you can go in and collect only up to the 25% of the past due. Now, it'll be very interesting because all of this presupposed that you gave this 15-day notice before September 30th. Now that we're passing September 30th, there's an open question in my mind whether the 15-day notice is still available as a way of trying to capture the past rent or not. Certainly, I know you can't do the 3-day notice to circumvent that, because you could collect no more than 25% of that rent as rent. What happens to the other 75%? You'd have to collect it in small claims. Okay, and so small claims, they changed the legislation. Small claims ordinarily for individuals is capped at $5,000. It's unlimited for past rent due in small claims, but you're going to be lining up with everybody all the landlords try to collect it. And good luck for all these COVID impacted tenants that had enough money to pay all the way through September 30th, suddenly finding money to be able to pay rent going back 12 or 18 months. But let's just focus on going forward, because what's happened in the past, how you recapture past rent, raises some questions in my mind. What is true is that through March of 2022, if you have a tenant, even in October, November, December, January, February, March of next year, you're still going to have to show what you had to show under AB 832 and SB 91 before it under Citra. But SB 91 introduced this back in February, which is the concept that you got to show as a landlord that you made a good faith effort to try to secure financial assistance for your tenants from the federal stimulus money that's been given to the states and counties and cities. So what does that mean? There is a various hodgepodge of programs that are available for tenants that are below 80% area median income. What is area median income? Area median income, you can look it up, but it's different for Santa Clara County than it is for Alameda County. It's different in Hollister or Sonoma than it is in our Bay Area counties. But there's a certain median income, and it depends. It's and some of the cities will have the website, or you look up the state, you might be able to find your area. It fluctuates depending upon the number of people per household. So a family with 6, their area median income has to be higher to accommodate the 6 people in the household than a family of 2 people. But in any event, if you're 80% or below that median income, you're eligible for financial assistance to pay the past rent that's due. Landlord has to go through an exercise where they work with the tenant to try to qualify for it. Well, if they don't do that, then their case is going to get tossed out at least through March. So somebody may be in the queue thinking, I've been patient, I've been waiting for this moratorium to lift. It's going to be New Year's for me as a landlord. I'm going to be able to start collecting my rent 100% and try to collect everything. Well, you can't do that without following additional steps. You're going to have to fill out a cover sheet. It's a mandatory civil case cover sheet, in addition to your unlawful detainer complaint, that specifies the steps you took. And if you collect that rent, obviously, then there's no rental arrearage at that point, and there's no basis for trying to recover possession. So that'll be the major, and there's still some tenant protections that exist under AB 832. You should consult with an attorney to understand all of the implications of it. But I guess the message for this, for purposes of this conversation, is that really we're still in a hybrid moratorium environment where landlords still have to work in trying to secure federal stimulus dollars that are eligible. There are certain other quirks. I don't know what's happening in Santa Clara County. I'll have to see what their moratorium said. But when AB 832 and SB 91 went into effect, the state made an effort to, and Citra, even before that in September of 2020, made an effort to create a uniform statewide rule as to landlord-tenant law. In fact, historically, all the laws regulating landlord tenants were from state law, with the one significant exception is that cities have the ability to impose rent control. Cities did not have the ability to deviate from what were the rules for sending out notices or recovering possession. That was all grounded in state law. But in March of 2020, the governor, by executive order, gave cities and counties the ability to regulate both residential and commercial leases And the commercial leases were always have always since been a matter of city or county control under the executive order that the governor had, which also expires on September 30th, but there was no statewide law. The only statewide law related to residential tenancies, which is, the moratorium is being lifted, as you say, on September 30th. But in Alameda County, it's been sitting there quietly in the background. And I have been asking my county supervisor and county housing people, what's the rule in Alameda County? Never got an answer back. While I was watching again this live news conference in Oakland on September 27th with Governor Newsom and Senator Skinner and other legislators. And there was an official from Alameda County say, well, the moratorium's lifted for the state, but not in Alameda County, which means if you have a tenant that's not paying rent in Alameda County or in Oakland, which has its own even more stringent ordinance, you can't kick them out until the county, or in the case of Oakland, lifts their declaration of COVID emergency. And so there's no current incentive. We got some of the lowest COVID transmission rates in the entire country. We have some of the highest vaccination rates. We're doing all the good, right things. But the political pressure right now in Alameda County, at least, is to keep these moratoriums in place to avoid displacement.
How about other counties?
Well, as I said, I'm going to have to look back at Santa Clara County. Santa Clara County was preempted, which is a fancy legal word, which means when Citra came into effect in September of 2020, because the state wanted to create a uniform statewide law, they preempted any ordinances that were amended after August 25th of 2020. Well, Santa Clara County had attempted to amend and extend its moratorium after that period. So Santa Clara County did not have a local moratorium in place. But there may be an argument that once the statewide moratorium is lifted, Santa Clara County, the Board of Supervisors may take the position that their moratorium is revived. It still is in effect now because it's the only game in town. So I'm going to have to make a few contacts and find out, but it's not a given that if you have a tenant in Santa Clara County, at least, that you can go in and try to kick somebody out as if there is no moratorium. Assuming the statewide moratorium is the law, just as a statewide proposition, you cannot go into court on any past rent due prior to September 30th until, or any kind of rent. I guess you could have a 3-day notice in October and they don't vacate until November of this year. So there's still a delay built in. If you have somebody you're evicting because you're trying to sell the house or some other just cause basis for evicting a tenant, you can go in beginning next month. But for non-payment of COVID rent, based on the fact that they claimed that they had COVID-related burdens, you cannot go in for that kind of unlawful detainer action until November 1st.
Wow. That's for Alameda County, right?
That's for statewide. Alameda County, you can't go in November 1st, December 1st, or maybe next year until the public health official in Alameda County says we no longer have a COVID emergency. And I don't know what their metric's going to be. As I said, we're among the best in the entire country of getting out of red into yellow, into orange, whatever the color code is. But the public health official might say, until we reach 90% vaccination rates among all eligible people. And now Pfizer apparently is introducing a vaccine for 6 to 12-year-olds that they want to get emergency use authorization. We may, expand who is eligible to 6-year-olds. They may have a really high threshold of vaccination rates that they want to see in the county before they lift the emergency. Because this was one thing that got lost at the moratoriums. Landlords would look at it and say, I've got mortgages to pay. Why do tenants get away for not having to pay rent and I still have to pay my mortgage? I understand that there's been an inequity. The federal stimulus dollars is supposed to resolve that by providing the money to the landlords for the past rent. The secondary issue, though, and the primary issue, though, for the legislature was a public health one. We didn't want massive relocation of tenants getting kicked out of their apartments, trying to find other housing, and having more congregate movements of masses of people spreading a highly transmissible virus. So maybe the state is going to be willing to take that risk now with the vaccination rates. But that was the reason why the moratorium had been in place. And in Alameda County, they may say, well, fine, we got our own moratorium ordinance. We're still going to be very public health conscious about the whole thing. And we're just not going to allow tenants to get kicked out for non-payment.
Oh.
Not a happy topic. I know it's frustrating for a lot of investors. I hear you.
Yeah.
A lot of hurdles.
Yeah. So what are some tips for these, these people to help lessen their burden?
Well, one of the things I'm thinking of, I would, thinking again, a disclaimer, I'm not giving advice, but if I was posed with this hypothetically, again, if you realize that you cannot collect more than 25% of rent for past rent due, you have a payment plan for that 25% rent and have maybe a gradual increase on the rent that you're trying to collect going forward if they're still dealing with COVID crisis. Because now you can collect 100% of the rent, but rather than going up to 100%, maybe make it 75% of the rent through the rest of the year. Have a payment plan for them to get caught up over time for the past rent that's due. It's a lot easier than trying to go to court and likely not being able to get a quick eviction. Secondarily, if you have somebody that's above 80%, you really don't have it. The tenant has, if you're trying to advise the tenant or trying to advise the landlord, tenant has no bargaining position because not only are they got rent past due, but the landlord's never going to get the tenant's never going to get reimbursement from federal stimulus dollars. So both the landlord and tenant are looking at a situation where it's a lose-lose for both of them. So again, develop maybe a slow payment schedule, over time. And the way I view it, that this is what I would tell people in a webinar. You have your good tenants. Certainly there are tenants out there that before the pandemic were gaming the system, and during the pandemic, you felt that they're trying to cut corners and maybe they didn't really have a COVID-related problem. Yes, there's some bad tenants. So a vast majority of them want housing stability as much as you or I do. And the way to ensure it is to stay current on your rent. So if they stop paying rent because of genuinely pandemic-related reasons, work with them and see if they're getting another job or something's happening where their circumstances have changed, where they can start paying rent going forward. You want to keep those tenants that paid. If you had a history with a tenant that they paid on time for 3 years before the pandemic and suddenly you had a pandemic dip, if they have the ability to do so, they're going to do so again. So work with them. That would be kind of the hypothetical approach I would take, is rather than an adversarial process where there's a lot of costs, a lot of problems where you may get tripped up and have to start all over again, it may be better to have some sort of agreement to try to, have half a loaf or 3/4 of a loaf on past rent, rather than being in a situation where you're trying to collect it against a tenant. And that's a very expensive and frustrating process.
What if this tenant is causing trouble to other tenants, maybe?
They're causing trouble to other tenants? That's an exception. If they're causing a nuisance and you got to get a police report, have the other tenant file a police report, you can go in immediately and get you can have a 3-day notice to quit because they've violated their covenants of not causing a nuisance. They're causing, or somebody's running a meth lab, out of their tenant, out of your home. Those are exceptions. You can go and get the court assistance, and that's not subject to any of these defenses that I've been talking about under AB 832. You don't have to show that you have tried to get financial assistance. It has nothing to do with rent. It has to do with they're misusing their space to the detriment of public health and safety.
Got it. Also, what if the landlord already tries to get funding from the federal or housing assistance, but is not getting any traction.
They don't get the funding that they're trying to get.
Yeah.
It's going to be up to the judge to say, is that good faith or not? If you show, and this is one of the problems, Cindy, you actually asked a very, very, all your questions have been good, but this is actually results in an insightful process of what is frustrating and can be frustrating for landlords. The way that the funding was set up is they've been put in different buckets. There are either buckets at the state level, buckets at the county level, and buckets at the city level if your city's large enough. San Jose is large enough that they got a bucket of federal stimulus dollars. Fremont is large enough that you get a bucket of federal dollars. It's only about 7.5 million, which is far below the need. But what did Fremont do? I don't know. I think internally, because they wanted to stretch the dollars to the most vulnerable, they were able to authorize rules that limited eligibility for Fremont's dollars from federal stimulus dollars to only 50% of AMI and below. So you could be a landlord of a tenant in Fremont who is 52% AMI and is not eligible for the Fremont dollars. Well, how much more good faith are you going to have to show? Now, setting aside, they're not going to be able to go into because of the moratorium in Alameda County. So they're not even be able to get past first base. But assuming they could, what's good faith in that situation? Because the way the rules are set up is if you're eligible, if you're in Fremont as a landlord, you can only tap the Fremont dollars. You can't tap the county dollars. That would be eligible potentially up to 80%. So you're penalized in Fremont if you have a landlord of a tenant that's above 50%. So there's these hidden tripwires that could cause an inability to get rent. But I've seen some indication that the landlord even has to secure or look out for potential nonprofit organizations that are doling out rent. So if you go to the Santa Clara County website in the housing section, and usually these are on the web page with the link to the appropriate page on the front page, they talk about some of the organizations in Santa Clara County that a landlord and a tenant should inquire to see if there's any dollars. And some of them are nonprofit, non-governmental. So the court might say, well, gee, even though they are above 50% or above 80%, did you try the Catholic Church? Did you try this or try that? The tenant's going to say, gee, there must have been some money somewhere and the landlord didn't check the box. And depending upon how the judge views that, that could be a gatekeeping threshold issue about whether the landlord can proceed with their eviction or not. So you're going to have a mini trial about if the tenant makes an issue, and the tenant will make an issue of everything if they're trying to keep a hold of their space to make a mini trial of everything. The other thing that's happening increasingly in this practice is that tenants have a right to a jury trial on an unlawful tainer. So what would be ordinarily in the past a court trial that would maybe last 45 minutes could be a jury trial that lasts 3 to 5 to 6 days on testimony. Well, that can end up for the landlord paying their attorney, $4,000 or $5,000 a day, depending upon the hourly rate and the preparation. So how many thousands of dollars are being spent there? And so what ends up happening is the courts are going to have these mediation services and a lot of off-ramps where you're going to get these skewed processes where the tenants say, well, maybe I'll give up, I haven't paid you, I probably refuse to help you get federal stimulus dollars. I don't qualify. I know that, but I'm going to fight you in court. And you may or may not win, landlord, and after a jury trial, and you're going to be out all these dollars. And if I win, I get to collect my attorney's fees too. And these are attorneys that work for free for the tenants, but still can make claims for attorney's fees for their foundation or whatever organization they're working for. So the landlord's attorney could be out, $30,000 and then paying $30,000 to the other side if it's a long jury trial. It can get ugly. And so in that situation, they go into these negotiating rooms and say, give me 6 months rent-free and I'll be out in, April of 2022. And you're going to say, well, that's horrible. That's terrible. That's, you've had all this free rent. You want me to waive all the past rent and be there for free for 6 months? But you sit down there and you start tabulating on the blackboard what the math is. And these are opportunity costs that the landlord has to weigh. The other thing that tenants do, and this was even pre-pandemic, is they get right to the point of a jury trial and they file for bankruptcy. And then you have to go to the bankruptcy court to get relief from the bankruptcy court to be able to proceed with your unlawful detainer. So there's all of these things that can build up for the tenant who is insistent and try to exercise all their rights and going then some to try to preserve their place. And it is now with these new rules to try to get secured funding from the federal government. There's more hoops for landlords that are going to have to jump and more ways to get tripped up. That after March of next year, when AB 832 ends, we may go back to a traditional landlord-tenant type of relationship. So AB 832 does have its own expiration date in terms of trying to find federal funding, at least. You can collect 100% of the rent now, but you're still under the same efforts that you were before September 30th in trying to secure federal funding. So after that March of 2022, unless there's an extension of AB 832 and there's more federal dollars that are made available to landlords and tenants, which is probably unlikely right now because the dollars are going in a different direction, that's probably when we're going to see something that is equivalent. So we've been through a 2-year cycle. You think about it, March 16th, March 17th was when we had the lockdown orders and shelter in place. So it'll be until March of 2022, 2 years later, before we're out of all of this.
Thank you so much for sharing your thoughts and your expertise, for sure.
Thank you. It's been a great privilege.
Any final thoughts you would love to share with everyone?
Well, I want to, again, thank you for this opportunity. I think that when we've dealt with the issue of housing in California, and now we're dealing with the issue of landlord-tenant relations during the pandemic, one of the lessons I think that we've all learned from the pandemic is that we have to develop some level of patience and equilibrium. We can't have highs and lows, and things are going to be, we live in particularly in Silicon Valley, when everything is sped up for us and we have information at our fingertips, we tend to think that all of our social ills and all of our health issues are going to be resolved in 24 hours at the speed of light. I think that the best approach is more of a philosophical one, is that there are rights and obligations that we're trying to create with our new housing laws from a public policy perspective, and certain rights and obligations as between landlords and tenants narrowly under the moratorium and the post-moratorium. We need to navigate them intelligently, with patience, with the longer view. And in that way, we can be more strategic in how we problem solve. I think it's a good life lessons, but it's certainly an approach that I take as an attorney and as a policymaker, that we need to be strategic in how we advocate, and strategic how we, whether it's advocating before a legislative body or advocating before a court, we need to take a strategic, longer view about how to best solve these issues. It can be found at my website, 3, the number 3, B as in boy, lawfirm.com, LAWFIRM.com. My email address tails off that domain name. It's D as in David, Bonaccorsi at 3blawfirm.com, and would love to be connected. And
you'll find me loser, set me free.